My lords, my lady, fortuitously in our submissions for this appeal, we referred to the judgment in Williams and Network Rail, where, of course, my Lord the Master of the Rolls approached afresh the tort of nuisance and set out the general principles. So if your lordships, my lady, wouldn't mind turning to that, it's at tab 27 in the second volume of Authorities. And the relevant passages are set out on page 613, beginning at the top in paragraph 38. And unless your lordships and my lady would like to read this themselves, can I just go swiftly through the relevant passages? In 38, your lordship says, in recent times a number of decisions at the highest level have introduced greater coherence and consistency to the legal principle governing the cause of action for private nuisance. The consequence is that it is neither necessary nor profitable to focus on historic cases of nuisance and the early development of the cause of action. Then skipping to the next paragraph, your lordship says he summarises the present principles of the cause of action of nuisance. We can overlook 40 and go to 41, where your lordship says, although nuisance is sometimes broken down into different categories, these are merely examples of a violation of property rights as I've described them. Then your lordship refers to Lord Lloyd's triple categorisation of nuisance in Hunter's case, and your lordship's comment, if I may with respect say the correct comment, is the difficulty with any rigid categorisation is that it may not easily accommodate possible examples of nuisance in new social conditions, or may undermine a proper analysis of factual situations which have aspects of more than one category but don't fall squarely within any one category, having regard to existing case law. And then the last passage I'd like to refer to is overleaf on page 614, a little over halfway through paragraph 43, just under letter F. And your lordship says what is relevant is the objective effect on the amenity value of the land itself, and it is that effect which satisfies any requirement there may be to show damage, provided by reference to all the circumstances of the case and the character of the locality, and according to the objective standards of the average person, the interference with amenity is sufficiently serious, there will be an actionable private nuisance. So that's the modern approach, my lords, my lady, and it's not particularly valuable in my submission to go back to what happened in the middle of the 19th century in any one particular case. Now, with that introduction to what in my submission is the modern approach to the tort of nuisance, can I turn to why we say that the appellant's grounds of appeal are wrong and should be rejected? And there are 5 things that I say in particular are wrong about Malone and Friends' approach. The first is that it is wrong to say that the judge simply determined that the question was whether the respondent's use of its land was reasonable, as if that was the be-all and the end-all of the judge's analysis. And I'll come back to that. The second thing that we say is wrong in the appellant's submissions is where they say in paragraph 16 that the relevant test is a threshold issue turning on the extent of the impact on the neighbour. And that's all one needs to consider. And they cite in favour of that proposition Ball and Ray, a case 150 years old concerning noises from a stable, and Vanderpant, a case 90 years old concerning noises from a hotel kitchen. Thirdly, my lords, my lady, the appellants say that it is wrong to consider whether their land or their use of it is sensitive. They say that's a completely irrelevant question to ask. Fourth, the appellants say that the judge was wrong to consider a hypothetical building. And fifth, they say that the judge was wrong to consider what precautions the appellants could have taken in this case to eliminate the nuisance. So if I may, I'll go through those 5 criticisms in turn. The first one I can take very shortly because your lordships and your ladyship heard a great deal about this morning. That's the question whether the respondent's use of its land was reasonable and whether that was a relevant question to ask in these circumstances. And it's quite plain if your lordships and ladyship read through Mr. Justice Mann's judgment from paragraph 180 onwards, 180 being where he introduces the question, that this is merely his gateway into his consideration of whether there was a nuisance here in the round. It is not his be-all and end-all, it's simply a stage in his analysis. And he goes on to consider other factors forming part of the balancing exercise we say he was required to carry out. Now, we agree, of course, that had the judge simply posed the question, is the respondent's use of its land reasonable, and then ended his judgment, that would not have been right. But when he asked the question, is the respondent's use of its land reasonable, we say that that was precisely the same shorthand which Lord Justice Carnworth characterised the exercise in Bar and Biffa. And a friend took your lordships and ladyship to the relevant passage this morning in paragraph 71 of his judgment, and perhaps I don't need to turn that up, but I will if it's convenient. Lord Justice Carnworth said in that case, none of this would matter if reasonable user, in the present case, was being used as no more than a shorthand for the traditional common law tests, as I understand it to have been used by Lord Gough. So that's all the judge was doing in this case. He was introducing the reasonableness of user, and he then went on there to use, from that, to use that as a springboard for considering all the various common law tests to do with locality and so forth. So it was a relevant question to ask. If the answer had been no, it's not a reasonable user, then that would have informed the judge's approach to the claim before him. We say in any event, my lords, my lady, and this is a proposition that really stemmed from the last few minutes of my learned friend's submission before the short adjournment, that one gets into great difficulty if one tries to apply the old test to the question whether use of land is necessary. My learned friend's example was, well, if I put up a roof terrace, it's then a perfectly normal facet of one's enjoyment of roof terrace that one should then use it. It's necessary to use it in order to gain the full amenity of the property. But of course, as I think my lady said, it wasn't necessary to put up the roof terrace in the first place. And in the same way with the Tate viewing gallery, it may not have been necessary to gain planning permission to put up the Blavatnik building, but having erected it, it would be absurd for it not to be used as a viewing gallery. That's its only purpose. So in that sense, it is necessary for the viewing gallery to be used as such. But, my lords, my lady, those philosophical considerations about what may be necessary in any given case illustrate in my submission why it's not terribly helpful to embark upon the exercise as to necessity in the first place. It's a far more holistic exercise, turning largely upon reasonableness. Second criticism made by the appellants, that the judge was wrong to consider anything other than the extent of the impact upon the appellants. Well, we say that's quite wrong. One starts this part of the analysis with the judge's conclusion in paragraph 88 of his judgment, if your lordships would just look at that. So, core bundle, tab 2, page 29. Page 29, paragraph 88, 2/3 of the way down. The heading to this part of the judgment is conclusion on the facts of the level of intrusion, and the judge's findings include C, the intrusion is a material intrusion into the privacy of the living accommodation, using the word privacy in its everyday meaning, and not prejudging any legal privacy questions that arise. Now, the learned friend would say, well, that was sufficient for the judge to really end his judgment by finding that there had been a nuisance in this case, because he's found, for material intrusion, one can pretty well read in substantial interference. It's the same sort of idea. But that's the end of the inquiry. That suffices for a finding of nuisance. So learned friend's approach is to say that having found that the activity was an intrusion, it has also to be actionable. No further inquiry is needed, no consideration of locality, no consideration of the appellant's own circumstances, no question of any balance. Learned friend's case, he expresses it in this way in paragraph 10 of his submissions, is the inevitable legal consequence of the judge's finding of fact is that the defendant is committing a nuisance. Now, my lords, my lady, in our submissions, what learned friend does in making that submission is to elide interference with land, which arguably those on the viewing gallery do, with unreasonable interference with land. And in our submission we say it is wrong to halt the inquiry, as the learned friend does, at the impact on the appellants. It is all about balance. And we have that repeated at the highest level through the authorities. It's said in those terms by Lord Wright in Sedley Denfield at page 903, and it's said by Lord Millet in Southwark and Mills in paragraph 20, which was read to your lordships this morning. But can I just take your lordships back to it? Just
what
to
was the page in Sedley Denfield?
Page 903, madam.
That's not in our authorities, I think, is it?
It is.
Is it?
Yes, it is, my lord. It's tab 9. So if your lordships are going to open that up, perhaps I can take your lordships to the passage in question, 903. So just to contextualise the authority, this was the college in London, which had extensive grounds. Somebody unknown to the college owners installed a culvert at the bottom of its land to take away excess surface water, but put in a drainage hatch in the wrong position, with the result that, through no fault of the owner of the land, great flooding was caused to the residential premises beneath it. And the claim that was brought against the owners of the land with the culvert upon it made their case in terms of not authorising the nuisance, and they failed on that ground. So that just provides the context. But going back to the point for which I cited, Lord Wright's judgment, page 903, is just below the middle of the page, underneath the citation of Coles. Lord Wright says a balance has to be maintained between the right of the occupier to do what he likes with his own and the right of his neighbour not to be interfered with. It is impossible to give any precise or universal formula, but it may broadly be said that a useful test is perhaps what is reasonable according to the ordinary usages of mankind living in society, or more correctly, in a particular society. That phrase, my lords, the usages of mankind living in society, is one borrowed from much earlier 19th century authority in a different context, but there it is used there. So that's Sedley Denfield. And then the other authority I briefly mentioned is Southwark and Mills. Perhaps your lordships would kindly turn up tab 17 in the other bundle of authorities.
Just getting back a little bit, I didn't get this down correctly. You said that Mr. Weeks had wrongfully elided two things. Can you just remind me? One was it reasonableness?
Well, no, he said once one finds interference with land under this test, then it must be unreasonable.
Unlawful, I think you said.
I hope I said unreasonable, my
You said
lady. If I said unlawful, I didn't mean to.
You said, or as I understood, you said the appellants denied interference with land and unreasonable interference.
Yes, that's right. It's exactly what I thought I said, my lord. Thank you. So in the second,
I wonder whether unreasonable is the right adjective, as opposed to, say, unjustified.
well, your lordship's quite right to pick up on that point. Unreasonableness is used in the context of the whole law of nuisance in a variety of different ways. And, my lord, it's really quite unhelpful when one's trying to make sense of the law. Unjustified, I think, my lord, with respect, is a much better way of approaching it.
Well, if you had statutory authority, for instance, you would be justified.
Yes, it might still be very unreasonable, but yes, quite. So, Lord, the authority, I think I said it was tab 17, it's in fact tab 18, Southwark and Tanner, and it's paragraph 20, which will now be familiar to, sorry, page 20, which will now be familiar to your lordships, where Lord Millet sets out the test about a third of the way down the page. And there he says the law of nuisance is concerned with balancing the conflicting interests of adjoining owners. Latin tag, this suggests a strict liability, but in practice the law seeks to protect the competing interests of both parties, so far as it can. For this purpose it employs the control mechanism described by Lord Gough in Cambridge Water, the principle of reasonable use of the principle of give and take. And the use of the word reasonable in this context is apt to be misunderstood. Really picks up my Lord Justice Lewison's point. It's no answer to an action for nuisance to say that the defendant's only making reasonable use of his land. And then if I could skip a few lines, because your lordships have seen this before, the governing principle, 6 lines from the bottom, is good neighbourliness, and this involves reciprocity. And then there's a reference back to Bamford and Turnley, with which learned friend commenced his submissions. So, my lords, I say from those two decisions at the highest authority, the question is to look at the balance and not just to consider the impact on one party. So I say this second head of criticism was quite wrong. The issue does not turn only on the extent of the impact on the neighbour. It has to be considered in the round by looking at a number of factors according to the usual common law tests.
So you're dealing still with the first of your 5 points, are you? Or are you on to point 2?
That was point 2, my lord. The first one focused on the criticism the judge had considered only the reasonableness of the respondent's use.
I see.
So you say, as to the first point, you say he looked at a lot more things.
Yes.
As to the second point, you say look at balance. He said Denfield and Southwark Mills.
Correct, my lord. And then my third point is the sensitivity point. Learned Friend says that the judge was wrong to consider the sensitivity of either the appellant's land or the use of it. And I say that is demonstrably wrong on the authorities. And if I may, my lords, my lady, I'll take a little time with this point. Now, littered through the authorities, one finds the careful caveat that in considering use and the impact on the neighbour's land, it's not any neighbour one is looking at, it's not quite right to say the reasonable man, but it's the ordinary man, according to the ordinary usages of society.
I suppose nowadays you have to be ordinary man or woman.
Well, or anything else, my lord. Yes, described in various ways through the authorities. So Walter himself says the standard of the plain sober man, but it's all the same sort of concept. And perhaps the most recent descriptor is that which we find in Bar and Biffa, if your lordships wouldn't mind turning to that in the second volume of Authorities, where Lord Justice Carnworth gives the judgment. So tab 24, and it's page 478. First hole punch, paragraph 71, letter C. Lord Justice Carnworth says none of this history, so he's just been dealing with Baron Bramwell's judgment, says none of this history would matter if reasonable user in the present case was being used as no more than a shorthand for the traditional common law tests.
Where are you?
Paragraph 71, my friend,
71.
page 478. So he's referred to the shorthand point, Lord Goff's formulation in, I think, Cambridge Water. And then in 72, Lord Justice Carnworth goes on to say, in my view, these complications are unsupported by authority and misconceived. Reasonable user should be judged by the well-settled tests. And he refers to Tony Weir's article, where he says, reasonableness is a relevant consideration here, but the question is neither what is reasonable in the eyes of the defendant or even the claimant. And here's the important part, for one cannot, by being unduly sensitive, constrain one's neighbour's freedoms, but what objectively a normal person would find it reasonable to have to put up with. I stress those words, unduly sensitive, in contrast to a normal person. So one concludes from that passage in a nutshell that something which causes harm to those of abnormal sensitivities, or to put the matter another way, to something of abnormal sensitiveness, does not on its own constitute a nuisance. Now the appellants don't accept that. Indeed, Learned Friend says in paragraph 35 of his submissions that as a matter of principle, a claimant should be able to establish a nuisance by relying on an interference, even if the interference only arises because of a particular sensitivity. Now, I say that follows neither as a matter of logic nor principle nor fairness. The bad examples with respect that the Learned Friend gives to try and found that proposition are the open-air theatre and the car parked on a forecourt, each of which is rained upon by dust from a nearby industrial process. Now, neither of those cases in our submission is a good example of a particular sensitivity, the perfectly ordinary uses of land. But the distinguishing feature from our case, the Tate case, is in the case of an open-air theatre, which is rained upon by dust from an industrial process, the nuisance doesn't stop when the theatre is roofed over. It continues unabated. The dust will pile up on the roof. It'll hit people as they leave the theatre at the end of the evening. And similarly in the case of the car parked on a forecourt. Just by putting your car in a garage doesn't eliminate the nuisance. It carries on unabated. It falls on the forecourt instead, on your property. And you're perfectly entitled to object to that. You're not being particularly sensitive by doing that. You're behaving perfectly normally. As I'll come on to say, my lords, my lady, the difference between those examples cited by my learned friend and the example of what we say should be done in Tate is if the perfectly ordinary precautions, well, I'll put this in two ways. First, if the building had been an ordinary building rather than a very sensitive building, the problem simply wouldn't have arisen, as the judge found, because there would have been no inducement to gaze, so no possible nuisance. But to put the matter another way, assuming the building as it stands, a normal use would be to use net curtains. It is a very specially sensitive use to insist upon using your glass-walled flat without any curtains at all. That is not a normal use, it's a hypersensitive use. So either way, whether you have a flat that is ordinarily constructed in the first place without glazing that invites the view, or whether you have the building as it stands but use net curtains as any ordinary person would, it's not a question of seeking to mitigate the nuisance. It's preventing the nuisance arising in the first place. And that's
But buried within the first way you put it are two, or maybe two separate points. One is, if the building had been what you call an ordinary building, I confess I'm not quite sure what that building is, not so many people would have looked at it. That's one way. The other way is, if it had been an ordinary building, then even if the same number of people had looked at it, it wouldn't have caused the interference, the intrusion rather, which the judge found.
Yes.
And they're two different concepts.
Your Lordship's right. Yes, I accept that. And in my submission, they both assist me.
With the sensitivity, and a sort of Robinson and Kilbert kind of sensitivity, only really goes to the second, doesn't it? If you had heated the building to the same temperature, it wouldn't have harmed ordinary materials stored on the floor. It's because you were storing particularly sensitive paper that you suffered damage. It doesn't say, well, you wouldn't have heated it to the same temperature.
No, I accept
So
that.
are you entitled to rely on both ways of putting it, or are you limited to saying, well, we've got to assume that the same 100,000 people looked at the flats, but they wouldn't have caused the intrusion? Because the judge seems to be mixing up a bit of both.
Yes. Well, my Lord, in my submission, I am entitled to say both. The same number of people, save for those circumstances when a newspaper publishes an article about Tate and lots more people come to look because it's in the news. But in the ordinary run of things, an awful lot of people come simply to look at the Richard Rogers architecture. And they would presumably come in any event. They're not there to spy into the appellant's flats. So the only thing that makes them look, those that choose to look, is the great areas of glass, which means that they can see into the flats. So if the flats have been built differently, then that simply wouldn't happen. And in the same way, my Lord, if the flats have been built as they are, but using privacy measures which any ordinary person would adopt, then again, there wouldn't be a nuisance. Not of the sort complained of.
But what is an ordinary building? What is that?
Well, my Lord, it's a difficult question. The judge evidently had difficulty with it. But in any case, when one is looking at abnormal sensitivity, one has to conjure up the counterfactual. Because it's unfair simply, and this is a point that helps them learn a friend, it's unfair simply to say this is an abnormally sensitive building, so you can't say that necessarily there's a nuisance. In fairness, you have to go on to ask yourself the question, say the building had not been abnormally sensitive, would there still have been a nuisance? Because if there would have been, then the abnormal sensitivity is a point that goes nowhere. Now, all the cases involving abnormal sensitivity, where the matter was relevant, the court had to go on to consider the counterfactual. And one sees that, my lords, for example, in Hoare and McAlpine, the very old building, imperfectly constructed, on land which was then forced to collapse by works going on across the road. And what the judge had to do in that case was to consider whether the building was unduly sensitive, and he would have gone on to consider whether it would have made any difference had the building been properly constructed. So there's a good example of the counterfactual. And it's always a hypothesis, my lord, because all one can do is to take the building as it stands, then ask yourself the question, is this an abnormally sensitive building, yes or no? If it is, there is then another stage of the inquiry. What difference does that make? And at that point of the inquiry, one is into the world of hypothesis, because of course it doesn't.
It wasn't explicitly done in Sullivan Mills, where the problem was inadequate soundproofing.
No, the closest one gets is, I think, Lord Hoffman's reference to a building with an inherent defect. And that's quite a valuable trail of inquiry, my lord, because, say, in our case, we have the building constructed as a normal building with lots of glass, but glass that acts like a one-way mirror. So one can see out, but people can't see in. So that would have been fine. That's not abnormally sensitive, and there wouldn't have been any intrusiveness, no inducement to view. But say through a fault in the manufacturing, the technology didn't work, so people in fact could see through the glass. Now in those circumstances, the appellants would presumably say, well, that's a nuisance, because you've got all your people looking to buy property. Now we'd be entitled to say, well, it's your fault, not ours. If you'd had your building constructed properly, this problem wouldn't have arisen. And we say, going on from that, why should it make any difference that the privacy measures which were meant to be introduced under the terms of the planning condition that was applied were not in fact built in by the developers? Why should that be laid at our door? And that makes it even more relevant in my submission, my lord, to go on to consider what the position would have been had the building been of normal construction.
Now, I don't remember the Horham McAlpine case, but was that a case of physical damage?
Yes, it
That
was.
was a case of nuisance causing physical damage.
Yes, yes.
Right.
The building
And
actually
what I'm
collapsed.
just wondering, and indeed in relation to that point and also your one-way glass point, is whether that isn't better analysed as a causation issue. What was the actual cause of the annoyance in legal terms, the proximate cause? Was it people looking, or was it the defect in the glass? And I don't know, but I would have thought there's somewhere bound up in there, instinctively I feel there's a causation issue.
Yes, and that's what the judge considered in this case, my lord. So he had to consider whether the gaze of the onlooker was something that was caused by the hypersensitive aspect of the building, the way it was constructed. So he did consider that, and his view was the only reason that people look into these flats is because of the way they're constructed. So there was a causation issue, and that's the way in which he answered it. My lord, my lady, our submission in the trial, which we maintain here on appeal, was that if you choose to live in a glass box, you are choosing an unusual habit of living. So here I'm looking at the matter the other way around. I've looked at the sensitivity of the building. Now I'm looking at the sensitivity of the use. So both ways of looking at that may quite well be summarised in the proposition that the building was constructed without real regard for the impact upon privacy that accompanies a glass design. It simply wasn't. It was meant to be, but as your lordships and your ladyship will have seen from the judgment, the privacy measures that were meant to be introduced were in the end dropped by the developer. And as we say in our submissions, no doubt for the reason that the flats were rather more valuable with floor-to-ceiling glass and a staggering view. And just to show you lordships how the matter involved in planning terms, can I just ask your lordship's attention briefly to the supplementary bundle.
Going back to this point of ordinary building, it came really in 2020, say that living in a modern glass-framed building is living, you know, in one of the great metropolises of the world, is living in an unusual manner. I mean, is that really
Oh, my lord, no, I
a
don't.
position that one
Yeah,
can
no,
make?
your lordship's quite right. I don't say merely that. Of course not, my lord. There are lots of glass wall blocks around. I say choosing to do so without using perfectly ordinary precautions is using the building in an unusual manner. Now, it obviously depends, my lord, where you are. This is all locality dependent. If you live in the middle of nowhere, in the Shires, and you choose not to have curtains on your glass-walled modern development, but then there's nobody passing, that's one thing. If you live in London, but on a quiet street, then lots of people, no doubt, don't have net curtains. If you live on Oxford Street with lots of people passing, I suggest it would be an ordinary use of your glass-walled flat to use net curtains. It all depends on the circumstances.
Of course, it's different for office buildings, many of which are entirely glass and look into each other from the position with someone's home, I suppose.
Yes. And indeed, rather, on that subject, my lady, rather closer to the flats in this case than the Tate Gallery itself is the Blue Fin building, which is, I think, only about 10 metres away. And it may be that some of the flat owners, I don't know, do deploy net curtains because they don't want to be subject to the gaze of the workers in the offices. But this was all considered below, and the judge said, well, office workers tend not to make it their business to stare out of the window at what people are doing next door. I mean, they may do. They're primarily there to work, whereas the Tate Gallery is there for people to look around. Now, I said I'd look at the way the matter evolved. The first document to look at, and I'll take this very quickly, my lords, my lady, in the supplemental bundle is tab 33.
Supplementary under authorities.
And
No, the ordinary supplement.
Oh, it's
not the authorities. Looking at
no, it's not an authority.
oh, I see.
my
I'm so
lord.
sorry. Yes, I see.
What? Now, page 331 should be the document that your lordships and ladyship find. And it's really not very clear, so an A3 copy is being handed up. So it's the right-hand illustration, my lord, and as the heading in text above says, diagram illustrating primary views and orientation, solar shading, privacy and self-screening. And there are then two blocks illustrated, which I think are meant to be B and C, but they're schematic. And one can see various colours for things. If your lordships and ladyships see below the triangular peak of each property plan, there are lines going down the flanks of the flats, diagonally left and diagonally right, and they have little nibs on them.
Those are the louvers, are they?
Those are the louvers, my lord, yes.
And what's the yellow crest at the top?
That's how the sun moves during the day.
Ah. And the Tate Modern, with that building, is at that part of the plan but a bit further away?
A bit further up the page, my lord, yes. So,
I see the nibs that are solar shading, they're called.
well, my lady, no, not entirely, because they also occur on the north, and of course there's no passage of sun, so...
No, but it says solar shading.
It says in that passage, my lady, yes, but at the top of the page the same nibs are shown, and indeed in the middle of the page one sees privacy where the sun does not shine. So the nibs were a privacy prevention mechanism
From one block of flats to the other.
from one to the other, but also, my lady, they were deployed at the northern end of the living accommodation, as one sees from from both northern aspects of each block. So that was the concept, my lady, in 2005 to 6, and that was then faithfully followed through into the planning application, where the same or similar detail appeared. That's all referred to in paragraph 35 of the judgment. And rather than take your lordships and ladyship to the planning drawings, which are hard to interpret, can I just show you how the experts dealt with this matter in the joint statement, which is in the same bundle but at tab 32. And if you turn to page 309, so this is both experts agreeing. They say in paragraph 27, the approved drawings, so these were the ones approved by the planners for the development, include 2 plans which demonstrate the broad types of facing materials, including privacy screen walls and louvers, as well as typical details of how they could be arranged. The drawings are listed as approved in the Planning Commission. On those drawings, it is relevant to note there is a significant extent of screening to the flats, shown in the form of solid or timber louvered panels. The extent of screening to other rooms is in contrast to the winter gardens, which were shown with full height single glazing and no screening. And then going to 28, given that Planning Commission was granted in accordance with these 2 approved drawings, any subsequent details implemented in the development should also have been in accordance with the broad types of privacy measure and typical arrangements shown there. And then to see what actually happened, one can just go over leaf in this. Paragraph 31. The condition was discharged by the council in 2009.
Which page?
Page 310, my lord, paragraph 31.
Yes, thank you.
So the condition was then discharged by the council in 2009. There's a reference to where the approved drawings are. And the experts jointly agree that they fixed the finalised location of privacy measures such as wooden screens and louvers across the facades of the 5 buildings. Comparison with the typical elevations shown in Appendix 9, i.e. the before position, shows that the final design for facing materials represented a significant reduction in screening for the flats when compared to the proposed typical levels for the upper floors set out in the approved original planning application.
The louvers that they're talking about, are those removable or do they open
No,
and
my
shut?
lady,
No,
they're built into the inside walls of the structure. And my lady, one can see what they look like by reference to the plan attached to the particulars of claim.
well, no, don't worry, I don't want to.
Well, my lady, can I take your ladyship to it anyway? Because it's quite useful to see the extent of the various protective measures that could be deployed.
So where was the passage you were just reading out?
Para 31.
Which part of paragraph 31 is it? Is it the introductory before the commentary?
Yes.
Oh, I
Yes.
see.
That's right, yes.
What do you want to look at now?
If your lordship would go to the slimmer bundle, the core bundle, tab 9. Page 138. So this is a plan attached to the particulars of claim, designed, I think, to show how close the buildings are. They're sort of 34 metres away from each other at this point. And the only purpose of referring to this is to show first the louvers, which are the light brown panels one can see on the inside face of the glass, and then various other treatments So one can see, for example, in the various flats that blinds are drawn, appearing either as light grey or dark grey or white. One can also see near the bottom of the page the first flat up, which is in fact flat 1301, belonging to one of the claimants. What appears to be a net curtain drawn all the way across the interior face of the winter gardens. And then the only other thing I'd single out is if your lordships and ladyship look at the top hole punch and read across the page, one flat down near where the structural members meet at a point, there's what appears to be a net curtain drawn across one of the window panels. So various precautionary methods. One is fixed into the building as a matter of design in the form of the louvers. In other cases, blinds and net curtains are used. Now, the judge summarises all the detail which I've just given the court in paragraph 43 of his judgment. So if you kindly go back to that, tab 2 in the same bundle. Page 18. He says in the middle of the page, paragraph 43, what ultimately happened was that drawings were submitted and approved which did not contain the louvers apparently appearing on glassed elements in the preceding application. There is some louvering apparent, but it is decorative wooden panels over solid structural panes. Thus, any proposals which might have involved creating privacy from form of structure disappeared without comment.
So what you just showed us in the photograph must be what he's referring to as the decorative wooden panels.
Yes, my lady, indeed. But my lady, they're fixed and they're part of the design of the building. There just would have been rather more of them had the planning condition been complied with. Now, my lady, my lords, given all that detail, we submit the judge was perfectly entitled to draw a conclusion. Indeed, it's obvious, we submit, that the building as constructed was a specially sensitive building as far as privacy was concerned. Learned friend submitted to the contrary this morning, repeating what's set out in his skeleton argument. He says, to the contrary, the claimant's flats are very well protected. Well, that's really not a submission he's entitled to make. It's quite contrary to the evidence. He inserts a footnote referring to another very tall tower block in the vicinity, a residential tower block known as 1 Blackfriars. But ironically, that building is one which has some form of internal mirror panelling, which makes it really very difficult to see in. That was one of the precautions which we had suggested that the claimants in this case should adopt. It's a well-known thing, one sees it, one sees apparent mirror glass all over London, and that's designed, it would appear, either for reasons of aesthetic or to protect privacy. So that's what's been used for 1 Blackfriars, so it's not a good comparator for a learned friend to use. Now, against all that, learned friend persists in saying that there's no such thing as a specially sensitive use, still less a specially sensitive building characteristic. And we say, well, wrong in relation to these circumstances, wrong by reference to the authorities. And if I may, I'll go through the leading authorities. I was going to start with Robertson and Kilbert, but I know that's very much in my Lord Justice Lewison's mind, so I won't trouble with that. I imagine that's well known to your lordships and your ladyship. But the passage that is worth emphasising in that case is one that occurs in Lord Justice Lopez's judgment. There he says, a man who carried...
Have you got the reference, please?
Yes, it's page 97.
In the bundles. Which,
it's tab 4 in the first bundle of authorities. And it's Lord Justice Lopez, page 97. And he says a man who carries on an exceptionally delicate trade cannot complain because it's injured by his neighbour doing something lawful on his property, if it is something which would not injure anything but an exceptionally delicate trade. And my Lord, I comment on top of that, but of course that introduces the hypothetical. One asks oneself the question, well, would this not merely injure your brown paper manufacture, but also injure anything else? So one has to consider the hypothetical. If the answer to that is no, it wouldn't injure anything else, it can't be a nuisance. If it would have injured other types of paper making, then perhaps it would have been. The authority which is worth spending a little time with, if I may, is the advice of the Privy Council in Easton, which is at tab 5 of the first pile of authorities. So it's a decision from 1902. Perhaps I can go straight to the summary of the facts, which is set out a few pages in on page 388. So Lord Robertson giving the judgment to their lordships at the bottom of that page. As the question raised by this appeal is whether the respondents are liable in damages for certain disturbances in the working of the appellant's submarine telegraph cable at Cape Town, that such disturbances did take place, that they were caused by electricity which had been stored by the respondents and used in propelling their tram cars in Cape Town and its suburbs, but from time to time had left the tramway system and found its way to the appellant's cable in the sea near Cape Town, and that losses resulted, are matters beyond dispute. There's a fuller explanation further down that page, but I don't think I need trouble your lordships and your ladyship with that. To find out what the respondent's argument had been, one goes back to page 387. So by the lower hole punch, if your lordships and your ladyship have this, it's the sentence beginning with neither. They say, neither under Roman Dutch law nor under the common law of England have the appellants a legal right to have their apparatus guaranteed at the respondent's expense on the slightest disturbance, more especially when the appellants could, by taking reasonable precautions, have protected themselves. And then there's a reference to Robinson and Kilbert. And then if I can go back to the judgment at page 392, just below the middle of the page, Lord Robinson says, now the kind and degree of interference with the respondent's property is pretty well illustrated by the fact that it can only take place if the cable is constructed without certain precautions. For given the cable as it now is, there is no injury. And I should explain that what they'd done by the time of the proceedings was to lay a twin cable which eliminated the problem. So these proceedings were really rather after the event. And then skipping to the last 7 or 8 lines on the page, Lord Robertson says, now if the instrument be taken as it was when the injury occurred, its nature is such that to ensure its immunity from disturbance is a somewhat serious liability to cast on neighbours. To describe this as a delicate instrument might be inaccurate, but in the present discussion this is not the true comparison at all. And then overleaf, I'll just read the first half of the page. He says, the true comparison is with things used in the ordinary enjoyment of property, and this instrument differs from such things in its peculiar liability to be affected by even minute currents of electricity. Now, having regard to the assumptions of the appellant's argument, it seems necessary to point out that the appellants as licensees to lay their cable in the sea, and as owners of the premises in Cape Town where the signals are received, cannot claim higher privileges than other owners of land, and cannot create for themselves, by reason of the peculiarity of their trade apparatus, a higher right to limit the operations of their neighbours than belongs to ordinary owners of land who do not trade with telegraphic cables. And then skipping 3 lines, the remedy at present invoked is an appeal to the common law principle, which applies to much more usual and less special conditions. A man cannot increase the liabilities of his neighbour by applying his own properties to special uses, whether for business or pleasure. Now, my lord, the facts could not be more different, but the principle, I submit, is the same. We say that the appellants cannot increase the liabilities of the Tate Gallery by applying their glass ball properties to special uses in the sense of their refusal, because of their interest in maintaining their view, to put up net curtains.
You're there, so in both of these cases, you're equating something that's carried on the land, which is particularly sensitive and might require protective measures. You're applying that scenario to where the land itself has a permanent fixture on it, because the building is part of the land, and what we describe as land.
Yes.
I mean, technically, that is the land. The land is the land. That's the substratum, the soil, and the building on it. Whereas these are activities being carried on the land. And so I suspect it would be said, well, there's a much closer analogy between a sensitive person, owner, and sensitive activities than there is between sensitive people and the land itself.
Yes, my lord, I take that point. And perhaps I can go to a couple more authorities to show your lordship that it doesn't really make any difference.
And at the end of the day, the question here, I'm not saying it's not an important question, it is an important question. The question, which so far you haven't shown us the case directly on it, because these are activities. The question is, in relation to a nuisance constituted by an improper interference with the amenity value of land, whether you have to take, according to the standards of an ordinary person, whether you have to take the land as you find it. That's the important question here, it seems to me. And you're saying, well, you don't have to take the land as you find it, by way of analogy with these cases. And that's really, it seems to be at the moment, the issue we're really addressing.
Yes. Yes. But my lord, my submissions are directed both at the use to which the land is put and to the state of the land itself. And in many cases, they're two sides of the same coin. So in the cable case here, one can either say that it's not right to use your cable with such sensitivity that you are specially affected by the operations of the defendant. Another way of putting the same point is to say you cannot expect that your specially sensitive cable can be used with the defendant being liable. So use and land are often interchangeable in these cases. Now, an example of specially sensitive land is one that was considered by the court, although the claim failed on its facts, in the next case at the next tab, which is Fearn McAlpine, tab 6, the decision of Mr. Justice Asprey. So, what was described as an ancient hotel on Lower Thames Street was damaged. Reading from the head note, in preparing a site for a large building in the heart of the city, the defendants drove a very large number of piles into the soil, thereby setting up such a heavy vibration as to cause serious structural damage to an old house belonging to the plaintiffs, with the result that the greater part had to be taken down in compliance with a dangerous structure notice. Now, the argument was that this was all because the plaintiff's house was in an abnormally unstable condition. That argument failed on the evidence. There simply wasn't any evidence of it. So ultimately, this did not turn out to be a sensitive user case, but it was all about it. Now, to go to the facts in a little more detail, your lordships can look at page 168, first line down. As originally constructed over 100 years ago, the building, had an interior cross wall from the basement to the top floor. This was chased into the southern and northern main walls, but not bonded. And at the north side, the building had certain tie plates tying it into the wall, separating it from an adjoining building on the north. And that was apparently the way things were built in those days. And then, just reading the first 3 lines of the next paragraph, about 50 years ago, the southern portion of the cross wall on the ground floor was removed for the improvement of the bar and replaced by 3 iron columns, and so on. And it goes through the various improvements or acts of destruction that were made to this building over the years. And then to the bottom of the page, my lords, my lady, in November 1920, the defendants, who were contractors for the erection of a large building immediately opposite the hotel, commenced driving a very large number of piles in the preparation of the hotel, and then that led to all the problems that transpired. And then if I can go to the paragraph between the 2 hole punches, the defendants, besides denying that the vibration had or could have caused any structural damage, said that if any such damage had been caused, it was due to the abnormally unstable character of the plaintiff's building, so no actual nuisance. And then to see how that argument is fleshed out, one turns to page 170. In colourful terms, in the first paragraph, the submission is made: the plaintiffs are not entitled to interfere with the normal use of their neighbour's property by maintaining a ramshackle building on their own land. This building was about as stable as a house of cards. This is simply an action of nuisance. It's not enough to prove damage. They must show an actual nuisance. In other words, they must make out such a nuisance as would affect normal persons or buildings of a normal stability, and citing, among other things, Easton and Cape Town. And then for the judgment, again over Leaf, page 171, this Justice Asper says, I'm clearly of opinion on the evidence that the vibration produced by the defendant's operations caused serious structural damage and injury to the plaintiff's building and resulted in the order to pull down, and I so hold. It is suggested by the defendants, without evidence, that the plaintiff's building might possibly have been saved in whole or in part if certain recommendations of the district surveyor had been carried out, which was not done. I express no opinion upon this suggestion at this stage of the case. I now turn to the question of law, which has been argued by the defendants. And if I can skip the next bit, last 5 lines of that paragraph, it is said that the laws to nuisance to human beings, as stated by the Vice-Chancellor in Walter itself, is really applicable to buildings, and that one must not be too fastidious in trying to limit the actions of one's neighbours. He then goes through the authorities, including Robinson and Kilbert, and perhaps I can go to the summary on page 174, halfway down, and just before that, the judge says the middle of the page, the fourth and last case relied upon is Kine and Jolly, where Lord Justice Vaughan Williams said, I think we must bear in mind that in these cases, which are conveniently grouped together as cases in which the proper form of action is an action of nuisance, citizens are not to be allowed to enforce rights which limit the user by others of property unless the facts relied upon as constituting a nuisance are such as to interfere with the ordinary rights which, according to the ordinary notions of mankind, they are entitled to exercise in relation to one another and in relation to their property. This is not contested. And then he goes on, next paragraph, the following proposition is sought to be established from these passages. A man cannot limit the operations of his neighbour on his own land or increase his neighbour's liability by putting his property for his own purposes into a structural condition in which it is more than ordinarily liable to be affected by that neighbour's legitimate operations. And now the judge's comment in relation to that submission is, in some circumstances this may be accurate. As applied to the present case, it is, in my judgment, inappropriate, and the analogy of contributory negligence does not apply. Now, my lords, my lady, we endorse that, but the reason it was inappropriate in that case was because the evidence simply didn't support the proposition.
So on one view, this case doesn't actually decide anything at all, except on its facts.
That's right, but, my lord, I use it for two purposes. The first is to show how the courts are expected to apply the sensitive user or building principle. Now, in that case, it failed on the facts, but the judge was apparently perfectly willing to apply it. And the other is that in order to ascertain whether this was a case of a building that only fell down because it was especially sensitive, one had also to look at what would have happened if it hadn't been especially sensitive. Would it still have fallen down? Now, there was no evidence of the case, so that inquiry was one which in the end ran into the sand.
Could also apply. It puts forward a proposition, presumably put forward by the defendant in this case at 174. It's a proposition. It's been sought to establish, and he says, well, in some circumstances, this may be accurate.
Yes.
I mean, it doesn't sound like the basis, if I may say so, for a very sound conclusion. That was the judge reached that as a matter of law. And obviously what had happened here was presumably counsel, in putting for that proposition, had made an analogy of contributory negligence. But I mean, can you really say that this is authority for the proposition that's being put forward there when all the judge says, in some circumstances, may be accurate?
Well, my lord, I use it merely as an example of a case where one party was trying to say, well, you destroyed my building because of your building operations, and the other party was saying in their defence, well, that's because your building was specially sensitive.
I mean, what you can, the most you, at the moment it seems to me, but others may disagree, the most you can get out of this is the judge did not reject the proposition.
No, that's right.
Do that. Yes.
Can I just ask you, whilst you're on this, to read the penultimate paragraph?
The whole judgment.
The penultimate paragraph of the judgment.
But even there, he's not saying that the defendant's contentions were right or wrong. He's saying if they were appetite, then there's a further question that arises.
Yes.
I mean, the submission that was made is the one at page 170, where Mr. Upton argued that damage in the present case was due to the abnormally unstable character of the building. Claimants are not entitled to interfere with the normal use of their native property by building a ramshackle building on their own land. The building is about as stable as a house of cards. That's the submission that he makes. Whether the judge accepts that as a proposition of law is not terribly clear, but even if it were right, it fails on the facts.
My lords, I'll move on. Bridlington and Yorkshire, which is at tab 10 of this volume of authorities, decision of Mr. Justice Buckley in 1965. So another case based on allegedly sensitive user, and in this case, what was said to be the allegedly sensitive user was the claimant's use of, in effect, a rebroadcasting station to give television to people in areas of the country that didn't get very good reception. And its means of doing that was interrupted by the activities of the defendant, who erected an overhead power line which disrupted the claimant's activities. Now, the passage of interest for my purposes starts on page 446, where the judge sets out the argument for the defendant. First paragraph in, judge sets out the defendant's contention that the plaintiff is using the aerial mast for a purpose requiring exceptional immunity from electrical interference, that not only are the aerials exceptionally sensitive to such interference, but the plaintiff's business is also one of a kind requiring a higher standard of interference-free reception than an ordinary viewer using a domestic aerial would demand. And at the bottom of the page, the judge says, I mention these matters because, in my judgment, the plaintiff could not succeed in an action for damages for nuisance if what I may call an ordinary receiver of television by means of an aerial mounted on his own house, could not do so. It is, I think, established by authority that an act which does not or would not interfere with the ordinary enjoyment of their property by neighbours in the ordinary modes of using such property cannot constitute a legal nuisance. And then he quotes from Easton and Robinson and Kilbert. And then between B and C on page 447, he says the dissemination of electrical interference is not, in my judgment, noxious in the sense in which I think Lord Justice Cotton is there using the term. It's in Robinson. Could such interference as is here in question be held to cause an interference with the ordinary enjoyment of life or the ordinary use of the plaintiff's property for the purposes of residence or business of such a kind as to amount to an actionable nuisance? And in the end, the judge held it was all premature because nothing had actually happened yet and there was no evidence of ordinary interference. So, my Lord, this authority is broadly consistent with the proposition I advance that if you have either an exceptionally sensitive use or an exceptionally sensitive building, you can't visit the consequences of that at the defendant's door. So,
To what extent does this issue coincide with the issue of locality? And did the judge find, in our case, that this building in which the claimants live was out of place in the locality?
he didn't find that, my lord. What he did do was to say that this was an extraordinary design. He didn't then go around looking at other buildings and locality to see whether they were similarly glassed. But it's the whole basis of his analysis when he considers the locality that this was a building that was effectively one which stood out by itself. He says as much in paragraph 190 of his judgment.
190.
Yes.
Because the comparison that's being made in these cases, including this one, is what would otherwise have been an ordinary use. Whether it be the very sensitive trade, or here television. The effect of electrical interference. And so what you're looking at is you're looking at the locality and the ordinary use of the land within that locality. Now here the use is an ordinary use in the sense that it's residential. It's residential in a building which is designed for residence, and although it's an exceptional building, I think you're saying the judge didn't specifically find that it was out of place in the locality as a place of residence. I'm just testing the proposition.
My lord, I'm listening. Yes.
And so I'm trying to fathom and assess to what extent these cases really help. So the first issue is these are all to do with things that are going on the land, and they're not really, apart from the one case we were referring to before, the McAlpine case, they're not really to do with the way the land's been built. Well, that's a bad expression. The identification of the land itself, which includes the building. The second point is, what underlies all these cases is within that locality and the use of the property for it's normally used, the user is unduly sensitive. So what I'm putting to you is actually neither of those particular features applies in this case. That's what I'm putting to you. What do you say?
My lord, let me put it this way. In the locality, and the judge had a very long site visit, this development was the only development involving floor-to-ceiling glass, apart from one Blackfriars, which was the one with the internal mirror material or cladding. So it was the only example of its kind, as far as I recall from the site visit, where this problem was capable of arising. Now, that feeds into my submission. These buildings were special. It was a unique feature of their design that they were floor-to-ceiling glass with very, very few privacy measures. Now, in contrast to other buildings thereabouts, it's an interesting area around Tate Modern. There are lots of office uses, which are to be left out of account because they don't really matter. There are quite a lot of residences which are old-fashioned, the little terraces of houses. So all those were there for the judge's view. And this development, the native land development, was the only one of its kind in the locality. It stood out. It was unique. So for your lordship to ask me whether the judge made a finding, whether this was typical or not, he didn't express it in those terms, but he undertook a very long site visit where, had anything else of that nature been evident, it would have been brought to his attention. There's nothing at all that I recall. So, my lord, it's not in my submission a very difficult point. The question is, given the way in which the building was constructed, which involved a fairly last-minute change of design to lessen the privacy features, is it a reasonable use of this property which invites the gaze from all and sundry not to use net curtains, or not to use the other precautions that are available, such as blinds, such as a net curtain across the interior of the winter gardens. And if one looks at this at a high level of generality by asking, is residential use normal? Well, of course it is, but residential use can be residential use with and without net curtains. Which of those two is a sensitive user, if either? And I say the one that is plainly sensitive, because it invites the problem, is not to have any form of barrier to the outside world at all. And my lord, we're only looking at the length of the day for 5 days of the week between 10 a.m. and 5:30 p.m. And what the claimants were saying in this case was, we should not have to lift a finger to put any form of barrier between ourselves and the public. We should be entitled to look at our view unsullied by any form of barrier at all. And I say that's precious close to asserting a right to a view, which of course is common ground. There was no such thing in this case. So, my lords, it's for those reasons that I say that the use in this case was specially sensitive. And it would not have been specially sensitive had this been in any way a normal building, or the building as it was, but used in a normal way with normal precautions. My lords, I won't go further with the authorities, but Southwark and Tanner is useful to an extent, and Network Rail and Morris too, which was in that case a recording studio, that's tab 21. I won't refer to it, but this too was another case where a claim was made that Network Rail were interfering with the sensitive use. That was the claimant's guitar playing. And what the court held was, this is something that was only brought upon yourselves because you were using your own premises for a use which was of particular sensitivity. So
But
it's...
wasn't it put in terms of foreseeability rather than sensitivity?
It was, my lord, as well. Yes, it was. That's quite fair. But can I just take your lordships to it, because it's quite interesting to see how the judge sets out his conclusion. So it's tab 21 in the second volume of authorities.
21.
That's
Tab 20.
Princess Caroline.
Yes, it's tab 20, I'm sorry.
Yes.
Paragraph. Yes. Yes, it's my Lord Justice Lewison's point emerged from the second paragraph of the holding at the top of page 862. So it wasn't foreseeable that the radiation would cause interference. It's the first holding. It was difficult to say in the modern era that the type of recording studio involved was so unusual as necessarily to disqualify M from the protection of the law of nuisance. This particular relationship demonstrated the question of sensitive use was no longer apt. What was required was an analysis of the demands of reasonableness in the particular case, and that comes from the judgment of Lord Justice Buxton, but the other two judges did not put it in those terms. And when extraordinary users dealt with, at the bottom of page 864 in paragraph 13, with a reference to Clark and Linsell, and then over Leaf, a nuisance of this kind to be actionable must be such as to be a real interference with the comfort or convenience of living according to the standards of the average man. An interference which alone causes harm to something of abnormal sensitiveness does not of itself constitute a nuisance. A man cannot increase the liabilities of his neighbour by applying his own property to special uses, whether for business or pleasure, and then a citation of Robinson and Kilbert, and then Easton at the bottom of the page. So, my lords, that's that case, and it's right to say that in the end it was analysed in terms of...
Just whilst you're on that case, if I could ask you to read the marked passage in paragraph 19. And also the marked passage from and the reference to what Lord Justice Buxton said is a reference to what he says in paragraph 31, 32 and 35.
not set up. in
So,
Justice.
my lords, the way in which the then Master of the Rolls, who conspicuously did not agree with Lord Justice Buxton's analysis, chose to characterise the test was that it was all these old rules were subsumed within a general test of reasonableness. And that prompts this rhetorical question from me. In what sense can it be reasonable, possibly, for the owner of land to seek to protect its rights without taking its rights to a clear view on the basis that it is not obliged to use its land in such a way as to protect itself? So what the claimants were saying here was, we don't see why we should use any normal precaution like net curtains, because we want to have our view unimpaired. And in doing so, it imposes a more rigorous obligation, a more rigorous burden upon the respondent in this case. There wouldn't have been any problem had this been a normal building, because there wouldn't have been a nuisance. But what they're saying is, we choose to use our building in such a way as to impose a higher burden upon you, because of the way in which it was constructed and because of our refusal to use net curtains. And my lords, my lady, in my submission, that's not reasonable. What they're doing, in effect, is claiming higher privileges than other, quotes, normal users of land in the vicinity, because of the way in which their property is being constructed.
But how does this submission fit in with the test that has to be applied? Did you say that therefore, there's no interference, or do you say the test is just, is it reasonable that they should have to put up with it having regard to what the Tate wants to do? You don't accept the sort of staggered test that Mr. Weeks was putting forward about first looking at the impact. I mean, the impact on them of the visitors has been found by the judge to be intrusive. But in what way do you say that that is negated by the points that you've just been putting to us?
Because, my lady, well, two reasons. I say that the only reason that there was a material intrusion was because the building had been constructed in a way that the developer had not set out to do. In the end, the developer had flung away the privacy measures.
Yes, I know. I
Right.
understand the points that you're making. I'm trying to see why they are relevant to the
Maybe
test that you
what the Master of the Roll said about causation. Yes, the gaze of the viewers was an intrusion. Why was it an intrusion? What caused it to be an intrusion? Your answer is because of the way the flats were designed and the way in which the inhabitants of the flats choose to live their lives.
Precisely, my lord. So it's a double-headed answer, my lady. It was only able to be intrusive because the claimants chose to buy flats which had been constructed in a way which made it obvious that if they didn't use ordinary precautions like net curtains, people would look at them. Now,
But there are a number of things that cause the intrusion. One of them is all the people on the viewing gallery, and another one is the absence of screening measures. So, what is the test for what has caused the intrusion then?
well, my lady,
I mean, if there weren't people allowed on the viewing gallery, then there also wouldn't be any intrusion.
no. So, my lady, one Yes, but one has to balance the way in which the defendant is using its land and its rights to do what it wants in a legitimate way with the rights of the claimants. Now, in this case, the inquiry proceeds as follows. Having found that it's a perfectly reasonable use of viewing gallery to use it for people to view, the next question is, does that cause a problem with the claimant's land? If yes, does that problem only arise because of special factors in relation to the claimant's land? If yes, then no actionable nuisance. For the reason, my lady, that if either the building had been built differently or if net curtains were used, there wouldn't have been any inducement to gaze. And that's what normal buildings and normal people are like.
I take that point. I'm just trying to fit it into some kind of legal schema as to what the test for actionable nuisance is.
Yes. Well, my lady, I say quite simply that when one applies the general rubric of reasonableness, one has to go back to these authorities on sensitive user. It can't be right to impose upon the owner of land a higher burden just because of the way in which the claimant has chosen to use its land. It just can't be right. It's always necessary to ask yourself, well, is there something specially sensitive about the way this land is being used that absent that would not cause a problem? And the answer to that question in this case is clearly yes.
Right, so you accept that the reasonableness of the Tate's use is not the sole criterion.
Of course, my lady,
Yes.
yes. My lady, we never said otherwise, and the judge certainly didn't either. It's a balance.
Now, just looking to see what actually was decided in this case about the reasonableness issue, that's Network Rail. Paragraph 19 deals with this. So, the master role there spent some time trying to work out how you apply the law relating to nuisance to electric or electronic interference. Paragraph 17. An attempt to apply the law of nuisance to electric or electronic interference encounters practical problems. And it deals with that. Then 19, he says, this is two sentences from the end of the paragraph. As Buxton LJ's judgment demonstrates, however, the law of nuisance has moved on. If resort must be had to it in order to resolve the competing claims of use of electronic equipment, the balance may fall to be struck. And again, that seems doesn't seem as though he's making his mind up about it. May fall to be struck by considering what is reasonable. And then he says, well, one thing is clear, foreseeable is a vital thing. And then he goes and considers it. So does he really actually, is this authority actually for a test of reasonableness in this context at all? I mean, he simply says it may be.
Well, that may be a matter for your lordships. Why should it not be, my lord?
All right, that's a different point. Insofar as you're citing this as authority, that there is a broad concept of that now the tests to which Mr. Weeks has referred us, as it were, are now to be subject to an overall gloss of reasonableness as between neighbours. I wouldn't have thought this was very sound authority for that.
No. My lord, I'm citing it primarily as another sensitive user case.
Well, I can see that. I do see the point that you're making, which is why should, once it's accepted that what you're doing on the land is particularly sensitive, and that may therefore exclude liability for nuisance. I can see the point saying, well, why should it be any different when the building is the same? I understand that. But moving on, this foreseeability point, is it in fact correct that you can only be liable in nuisance, even if it results in physical harm to your neighbour's property or whatever you're doing, if you should have foreseen it? Is that the law now?
Well, my lord, there's a
Forcibility is an essential ingredient.
My lord, there's a lot of academic controversy about the role that foreseeability plays in the law of nuisance. It didn't arise in our case, and my lord, it's not possible to give your lordship a definitive answer to that question.
I thought that was what was decided in the Cambridge case,
Uh,
where there was a leakage of chemicals, but not foreseeable.
well, my lord, yes, it was in that case, yes. But, my lord, I'm aware there is much academic controversy about the question.
You're right, it doesn't arise here. But
It doesn't arise here.
Thank you.
Now, if your lordships and your ladyship are with me so far on the question of the role that sensitivity plays, then in my submission, this is my fourth point now, one inevitably gets to the question, which is, as I say, a point in favour of learned friend. You don't just say it's sensitive, therefore no nuisance. You have to consider the counterfactual. Would it nevertheless have impacted an ordinary use? So, out of fairness to my learned friend, although I don't think the judge quite put it that way, it's a relevant part of the inquiry to go on to consider, well, so what? We know that this has impacted the use of a specially sensitive building, or has impacted a specially sensitive use. In fairness to the claimant, one must also then ask, yes, but is that the end of it? Or what would have happened had there been no special sensitivity? And if the answer is, well, there still would have been an impact, then there must be a finding of nuisance. So when considering his hypothetical building, the judge was entirely right in my submission to take that step. Now, because it's hypothetical, it's very difficult to give it shape and form. But the judge was assisted by the fact that he'd had a site visit, he'd had the planning drawings showing what was intended to be included by way of precaution. He also had the evidence of those rooms in these glass-walled flats that were, quotes, ordinary. So the bedrooms, the bathroom, which were of perfectly ordinary construction, as he notes in his judgment. So, in looking at a comparator, he didn't, in my submission, have to sit down with an architect and draw up a building of the sort that he had in mind. It was perfectly sufficient in my submission for him to say, well, this is the sort of thing, more vertical and more horizontal definition, an ordinary building. My lord, with respect, I think it's probably right that all of us have in mind what in the 21st century can be regarded as a normal residential building for living in. And in a built-up busy area like Tate, one would visualise, I suggest, as the judge did, either one with proper walls and smaller windows, or, if all glass, then one with net curtains. Now, that's not a voyage of fantasy. It's merely an inquiry necessarily into the counterfactual. You can't just say, oh, well, who knows what an ordinary building would have looked like. We all have conceptions of that. And that's what the judge did. And he was doing it in fairness to the claimants, to see if, nevertheless, it would be right to make a finding of nuisance.
The trouble is, if you ask somebody, who lives, who knows London, it's London, it's right in the heart of one of the most dense tourist areas, populated areas in the city we're talking about now, and you said to them, what's an ordinary house in this area? I mean, would they really say, well, it's quite obvious it's going to be bricks and mortar and a few windows? They'd probably say, well, would they like to say, well, who knows, it could be anything.
Yes, but, my lord, that's...
The thing is, you keep on using these words normal and ordinary.
Yes, I know.
That's what I'm picking up.
Yes.
I mean, is there a concept of normal and ordinary in this location? That's really what I mean. Is there such a concept?
Well, my lord, the counterfactual was a matter for both parties, and it was more in my learned friend's interest to say to the judge, well, in this area, this is a perfectly normal type of building, and nobody uses net curtains. Now, that was an evidential task for him, not for me. And, my lord, the judge made up his own mind on this. It was not without the benefit of argument. I made submissions on the topic. And as I've said repeatedly, the judge had the benefit of a long site visit to see what was normal in the locality. Now, if you really want to say, the judge having found especially sensitive use, that the counterfactual wouldn't have been any different, that's your burden. That's for you to prove. And in my submission, whatever a normal building might be, a normal use, if you do have floor-to-ceiling glass, is to use net curtains. Or to put up with being looked at, if that's what you liked. And on the site visit, my lord, it was quite plain that some people did like being looked at. We saw evidence of them parading themselves in front of the judge's view. But, as I say, I don't think it's a big leap, my lord, for the judge to have come to the conclusion that normal people in these circumstances, with this type of building, would protect themselves with net curtains.
All right, I don't know how I think we would like you to address this also on the justiciability point when you're ready to do so.
Yes, my lord, I'll come on to that after my fifth approved submissions, which was the precautions that the appellants could have taken. And this is all part and parcel of the same issue. It's not really a separate point. But we do say it's relevant for the court to inquire into what sort of precautions that the claimants could have taken in this case to change the sensitivity of their building to something more normal.
There was some suggestion at some point that there was a restriction in the lease preventing them from using net curtains. Has that been investigated?
Yes, your ladyship's quite right. The lease itself, my lady, is in the larger bundle, the supplemental bundle, so not the bundle of authorities. Tab 38. And the restriction in question is on page 376. So in the middle of the page, paragraph 24 of, this is a schedule to the lease, there's a ban on double glazing of certain sorts, and then 3 lines in it says, and not to cover the windows with Venetian blinds or dress the windows with curtains which would be detrimental to the external appearance of the block, provided always curtains with a white or cream lining are acceptable in the premises, and then there's an exception carved out of that, save solar blinds only of a type specified by the landlord shall be used to dress the windows in the winter garden forming part of the premises. So, my lady, going through the twists and turns of that drafting, you can have curtains with a white or cream lining in the premises generally, apart from the winter gardens where you can only have a particular sort of solar blind. Now,
So they can't have net curtains.
Well, my lady, we then marry up that evidence with the evidence in the case from Native Land, who were asked about this, and tab 34 of the same bundle. Page 342. So below the blacked out bit, this is an email from Native Land to Mr. Hislop of Tate. He says, Donald, the standard lease does seek to unify the window treatment across the development, as typical in residential buildings in London. However, several apartments around the development, it is the colour which is most important to control. Bankside still controls the management of the buildings until the residence committee is established after the sale of the last unit. Therefore, it would be possible for that technical restriction to be removed I note, however, that we have not been asked by any of the residents if they can erect blinds, and would, of course, not restrict this, far from it. So, that answers your ladyship's point. The landlord was asked, and your ladyship's seen its attitude from that email. So, there was...
In other words, they don't consider it to be detrimental to the external appearance of the block.
Right. And to follow on your lordship's point, I've shown your lordships the photograph attached to the particulars claim. That does show, albeit in fairly small measure, that some parties do use net curtains, and also all types of blinds of different colours, apparently without any
They may be
objection at all.
breaching the lease, but that's not quite the point, is it?
No, but we do have the landlord saying, of course they can. So, that's that point. So, my lady, the winter gardens, of course, are off on a limb, as it were, because their different standards apply, as we see from the
What is
judges.
GC Bankside's relationship with native land?
They're the managing agents for the building employed by native land, my lord.
So they are, so GC Bankside are the managing agents,
Yes.
and not the landlords.
No.
So you haven't actually got anything from the landlords.
I'll just
What it's worth.
Well, I thought that, isn't Mr. Clark from Native Land, isn't he from the landlord?
Yes, and this is an email emanating, my lord, from the landlord. So this is the managing agent conveying what the landlord's view is. Yes, the native land is the landlord.
It is,
Yes, GC Bankside is the manager.
that's the age. Okay. Thank you.
So, my lords, my lady, I won't take you in the interest of time back to the joint statement where it records what measures had actually been taken on behalf of the claimants to screen their views. But shortly the answer is none of them had taken any steps whatsoever, in contrast evidently to some others in the building who had. Mr. May, the expert appearing for the appellants, said in evidence that the steps would have been cheap to take, and there was no reason why they shouldn't be taken. But it was the claimant's preference that the Tate, at rather greater expense, should either stop the southern use of its viewing gallery or put up some form of architectural barrier to the view. And in our submission, that's not the right balance to strike in this case. It's wholly disproportionate, comparing net curtains to...
Does that mean in a case now concerning noise, for external noise, for example, that it will be a defence for the defendant to say it would be perfectly reasonable and we're prepared to pay for double glazing?
If double glazing made no difference to amenity, but stopped the noise, yes, my lord. And there's a very similar case on point, my lord, a decision of Sir Michael Hardy Boys in the 1980s in Bank of New Zealand, which is in the bundle as well, tab 16, where the nuisance alleged in that case was a dazzle reflected from a building across the street. And the dazzle the judge held was a nuisance. In the end, there were two occupiers of the claimant's building. One was an office occupier, but that had Venetian blinds installed, and the judge said, well, the remedy's in your own hands, just use your Venetian blinds. You're not suffering a nuisance, save to the extent that you choose to keep them open. So just do that which is obvious. In relation to the bank part of the premises, which didn't have Venetian blinds, the expedient the judge adopted was to say, you can remedy the nuisance in whichever way you think best so as to eliminate it. And one feasible way of doing it, which the judge held was the right way, was for the tortfeasor to go into the claimant's premises and install blinds in their premises. And he said if the claimants didn't want to put up with that, then
Is an authority you want us to look at?
well, yes, it is. It's tab 16 in the second bundle of authorities. Yes, I'm sorry, it's 16, my numbers are out.
This is a New Zealand case.
Yes, it is.
First instance New Zealand case.
Yes. My lord, this Justice Hardy Boys was subsequently appointed to the Court of Appeal and became Governor General in New Zealand as a historical footnote, a celebrated New Zealand judge. So he says at the bottom of the first page, and I'm sorry that the numbering is quite difficult to see on some of the pages, he says the case raises in an interesting way the difficult and important problem of reconciling conflicting rights and interests in modern urban society. And can I flip on from that to page 8? So it's a faint number at the top of the page, my lord.
Yeah, oh yes.
First paragraph in, he says, counsel were unable to refer me to any reported case in which a court had been required to determine whether the reflection of sunlight can amount to an actual nuisance. And then he's just skipped the page, the last 3 lines. He says, the dearth of authority should, of course, present no great obstacle. For nuisance is one of those areas of the law where the courts have long been engaged in the application of certain basic legal concepts, and so on. And this is all heartwarming stuff. 2 pages on, he sets out the test on page 10. The number may be too faint for your lordships to see. And then he goes through all the authorities in the way in which your lordships have been asked to do today. And then at the top of this page, if your lordships find page 11 as a useful jumping off point, and go on from that to the next page, page 12, and at the bottom hole punch, this is where he's distinguishing between the 2 types of occupant of the property, the claimant's property. He says, last 3 lines of that paragraph, whilst the plaintiffs are able almost entirely to alleviate the problem by installing and then drawing curtains or blinds. So that was the argument for the defendants. And then going over Leaf.
Is that the page beginning and striking the balance at the top?
Yeah. So
Yes.
the second hole punch.
That's it. So second hole punch,
Oh, I see. So,
the argument for the defendants,
thank you.
they said, in much the same way one might think, as I'm saying in this case, the plaintiffs are able almost entirely to alleviate the problem by installing and then drawing curtains or blinds. Next page, 3 lines down, he says the plaintiff's ability to shut out the nuisance cannot be more than a factor to be taken into account in considering whether the interference is at an unacceptable level, if only because a line would somewhere have to be drawn between what could and couldn't be properly be expected of him. It can't be determinative of liability. And then last 3 lines of that paragraph, to hold otherwise could be to require the plaintiff to remedy the defendant's wrong.
Well,
And the
there,
law,
he seems to be saying it's not a causation issue. It's a what is the extent of the interference with your amenity issue. Does one take into account when assessing whether the interference with your amenity is serious or not, your ability to mitigate it yourself?
yes. Now, my lady, I'm dealing with the double glazing point at this stage, but transferred into the facts arising in this case. So yes, the judge was considering, but ultimately, as we've seen, as we will see, rejecting the proposition that it ought to be up to the claimant to get rid of the nuisance by taking its own preventative measures. Now, ultimately, well, I'll show your ladyship in a minute what the judge actually did in that case, but in my case, I say that the same principle doesn't apply because we're not asking the claimants to, in some way, mitigate the nuisance we're causing. We're saying, just use the premises ordinarily as anybody would, instead of trying to preserve your right to a view, and there won't be a nuisance at all. It's not a question of mitigating the nuisance or trying to get rid of it. You won't have a nuisance if you do what we say you should do and use net curtains. Now, in this case, that argument didn't work because the nuisance would have continued unabated, notwithstanding using blinds, and the sun would have continued to dazzle. It still would have been there. So it's not like our case. But what's quite interesting about this case is that the judge held, first in relation to that occupier which already had Venetian blinds, and this is the middle of the next page, where the paragraph in the centre begins, however I limit. The lordships have that. He says, I limit that conclusion to the bank and challenge properties. I consider that Duncan Cotterill, which was the office occupier, are in a different position. Whilst it may be awkward, I don't think it unreasonable for persons in offices fitted with Venetian blinds to have to close these when necessary to keep out the glare, or even to keep them closed while the likelihood of glare persists. It's a perfectly normal thing for people to have to do. It's a part of what Venetian blinds are designed for, and so on. And then at the last two lines on that page, he says the situation is obviously different with those windows which are not presently fitted with blinds or curtains. And then he comes in the middle of the next page to the exercise he thinks is required, which is a balancing of competing considerations. And he ends up by saying that there is an actionable nuisance for the office occupier, for the bank occupier. And then the penultimate page, first hole punch, he says, I consider that the glare is not an actionable nuisance where it can reasonably be excluded by drawing Venetian blinds, so that's the office occupier. The provision of blinds, I accept the curtains won't do, but vertical Venetians seem entirely suitable. At the defendant's expense would thus satisfy the plaintiff's rights and discharge the defendant's obligations. It would achieve these results at what is likely to be a much lower cost to the defendants, both in terms of money and detrimental effect. And then halfway through the next paragraph, he says, it's in reality allowing the defendants to choose the means by which they will eliminate the nuisance. They may indeed prefer to eliminate it at its source, which would mean demolishing the balcony across the road, but I consider that they are entitled to deal with it as they prefer by reducing its effects to reasonable limits. Now, that part of the judgment we endorse, my lady, my lords, because we say that transplanting that principle to this case, it would have been perfectly fair for the judge to say that had there been a nuisance, one possible way of remedying it, instead of the Tate taking action to its own building, would have been to gain access to the claimant's building and install net curtains. Now, of course, that's something open to the claimants to do for themselves as they wish. Indeed, many of these flats were fitted with net curtains in the first place, as we see from the photographs.
I'm afraid we have to rise at the latest, because I've got another appointment, I have to rise at the latest at 25 to 5.
Yes. My lord, in those circumstances, I will move on to the point on which I know that your lordships and ladyship want me to address. I did have one final head of submission to deal with, and that's the one which it's really all a question of fact for the trial judge. This
Is that
not
your
just-
sixth point?
Well, my lady, it's an entirely separate point, but it doesn't matter. Now, your ladyship will recall the case in which your ladyship was involved, dealing with shareholders, where the appellants were seeking to overturn a judgment below, and your ladyship's comment was, well, it's all a question of fact, and it's very, very difficult for the Court of Appeal to put it into the position of the trial judge. And your ladyship cited a judgment of Lord Justice Lewison, where he talked of island hopping in the sea of evidence and how unsatisfactory it is for the Court of Appeal to deal with that situation. And I put a reference to the case. It's Prescott. It's in the bundle of authorities. I commend that to your lordships and your ladyship. I say it's much worse in a case like this, where it's not merely a question of the judge having heard oral evidence recorded in a transcript.
That was the unfair prejudice.
Yes, it was, my lady. Yes. It's much worse in a case where it's not just to do with written evidence and oral evidence which can be read in a transcript.
So I made a mistake. I've been reminded by Justice Lewison. This is listed for half day tomorrow as well. I'd forgotten about that.
I'm very glad that you're yes, my lord. I knew that, but
Yeah, I'd say so. I completely forgotten about that. Then I can ask another question in that case, which is, how do your submissions fit in with the well-established rule that it's no defence to come to a nuisance? The claimant has come to a nuisance.
well, my lord, they accept that. We didn't argue to the contrary below. So I don't say, well, you made your own bed here, knowing that the viewing gallery was being constructed. And in the evidence, my lord, at least one of the claimants had known about the viewing gallery and had thought to himself, well, I'll go ahead with the purchase anyway, because how bad can it be, not appreciating how bad it would be. So some of these claimants bought their flats knowing that there was a viewing gallery under construction, and indeed some of them could see it in its bare bones form. But, my lord, we didn't say in relation to that category of people that they came to the nuisance and therefore they had no claim. We never made that submission. So my submissions to your lordships and ladyship, I hope, are consistent with the principle that it is no defence to say you've come to a nuisance.
So if they sold their flats to somebody now and who moved in, that person would have as good or as bad claim as the original owners.
My lady, that must be right.
Yeah.
Yes. Yes.
Is the special sensitivity point that you are making, is that analogous to the eggshell skull? That you've got to get over a certain threshold of injuring somebody, but once you've passed that threshold, you then take the claimant as he is.
Well, my lord, it sounds similar. I think it's a completely different test, because that comes in when you're weighing up the damage that's suffered rather than whether there's a cause of action in the first place.
Well, a cause of action may require some form of damage.
Yes, yes. My lord, it's merely similar, but it's different in effect. In this case, we say the special sensitivity has nothing to do with the individual characteristics of the claimants. Rather, it's to do with their refusal to do anything that might block their view. Well, well, Lord, I know that your lordships and ladyship are anxious to get on in general terms anyway, but if I can proceed without rushing quite so much, I'd quite like to refer to that authority I was citing. So it's footnoted in our skeleton argument, and it's at tab 26 of the second volume of authorities. So, your lordships and ladyships should have re-sprint room, decided last year. And if I can go straight to page 622, just to refresh my lady's memory, see what the action was about. So, first hole punch, paragraph 3. The first action was a claim by Sprint against Dr. Patamianos in respect of certain intellectual property rights and software. And then there was a second claim about unfair prejudice. That's, I think, all I need to say by way of contextualisation. And then if you would go, please, to page 636. See what the complaint, how the complaint was presented on appeal in the middle of the page. Paragraph 60. The crux of Mr. Prescott's complaint is that having found as he did that Dr. Tamianos was in breach of his fiduciary duties, and so on, the judge ought to have found that he was not entitled to relief on his unfair prejudice petition, and so on. And then page 639. If I can go to the top of the page, paragraph 68. The first submission on this part of the case was that we should only interfere with the judge's conclusions on whether there had been unfair prejudice if we found that the judge had not merely preferred an imperfect solution which is different from an alternative imperfect solution which the court of appeal might or would have adopted, but has exceeded the generous ambit within which reasonable disagreement is possible. And then there is much that I hope will be of assistance on this question. Perhaps I can just skate over some of that. Paragraph 72 near the bottom of the page. The question of the room for appellant challenge of such an evaluative decision is an area of our procedural law which has attracted much attention from appellate courts in recent years, possibly fueled by the ever-increasing complexity and detail of some litigation. In such litigation, it's very difficult for appellate courts to put themselves in the same position as trial judges in making those decisions, based as they are on voluminous documentary and or oral evidence, which can be summarised, which can only be summarised even in an extensive judgment at first instance. In our judgment, this is such a case. And then if you would be kind enough to read from that point on to paragraph 420 on the next page. I'm sorry, down to page, yes, the end of the quotation from paragraph 420, halfway down the next page. Well, I'm sure it is, and indeed all the more so because on page 642, your Lordship's own words are quoted in paragraph 78, citing from Phage, don't interfere with findings of fact by trial judges unless compelled to do so. So not only the findings of primary fact, but also the evaluation. And then your Lordship's reasoning is then set out on page 643 at the top. Your Lordship says, among other things, the trial is not a dress rehearsal, it's the first and last night of the show. And then 4 is the bit I referred to earlier. In making his decisions, the trial judge will have regard to the whole of the sea of evidence presented to him, whereas an appellate court will only be island hopping, and the atmosphere of the courtroom cannot in any event be recreated by reference to documents. So that was a case where the evidence just consisted of documents and oral evidence. And the point I was making earlier was that it's all the worse when the evidence includes a site visit, which of course can't be replicated in any meaningful form other than by what the judge chooses to set out in his judgment. That was my last point. Be wary of upsetting cases where there are evaluations drawn from findings of fact. My lady, my lords, let me now turn to the point which arose yesterday in the Master of the Rolls clerk's email. And the letter friend made 6 points just before the short adjournment. His first point was that Tate, the respondent, conceded that privacy could be an aspect of the amenity of land, referring to paragraph 169b to c of the judgment. My lord, that's not accurate. The concession was limited to malice. And that in turn allowed the judge to say that my concession gave the game away at the level of principle. But the point that I'd been making below was that there was nothing wrong with ordinary overlooking. The cases on nuisance dealt with overlooking by saying that if it was malicious, then it was actionable. If it wasn't malicious, it was not. And there grew out of this distinction the aspect of the tort of nuisance, which was known as watching and besetting. So that was the way the law chose to deal with overlooking in the old days. Of course, watching and besetting has really ceased to be a matter of any relevance because of the Protection from Harassment Act, under which it's now subsumed. So there was no general concession by us that privacy could be an aspect of the amenity of land. That's the first point. Secondly, my learned friend submitted that Miss Justice Mann thought that even absent Article 8, nuisance would probably protect privacy, especially from overlooking. And that's what he says in paragraph 169. Well, that's not a human rights point. It doesn't depend upon extension at all. That was just the way the judge chose to analyse the problem in terms of nuisance. My learned friend's third point was that the planning system offers insufficient protection from invasions of privacy by overlooking, whether for the purposes of Article 8 or generally. And his reason for saying that is because the planning system is not designed to protect the rights of individuals as distinct from the overall public interest. Well, that may be a defence to a claim in nuisance, but it's not an answer to Article 8. Because under Article 8, the obligation on the state is to take reasonable measures which take account of the competing rights at stake. The approach to be taken to the application of positive obligations is similar to that to be taken in the analysis of Article 8 too. Now, it's wrong in my submission to focus just upon the planning system. That's one of the protections for citizens, but it's only one of them. And can I just refer your lordships and your ladyship to what was said in Wainwright, itself a decision of the House of Lords. Common law torts include trespass, nuisance, defamation and malicious falsehood. There is the equitable action for breach of confidence and statutory remedies under the Protection from Harassment Act 1997 and the Data Protection Act 1998. There are also extra legal remedies under codes of practice applicable to broadcasters and newspapers. So,
Which page was that?
paragraph 18 of Wainwright, which is in the supplementary bundle of authorities that was handed up earlier. So there are other protections available besides the planning system. And even when one is looking at the state and the actions it should take to safeguard the privacy rights of the individual, the fact that there may be gaps in the existing level of protection doesn't mean that there's a breach of the state's positive obligation, because it's got a margin of appreciation, and that's the point that von Hanover makes in paragraph 57.
We are dealing with a particular complaint which is overlooking, which is only a subset of intrusion into privacy.
Yes.
I mean, suppose that in a terrace house somebody puts a microphone, or receiver rather, on their own party wall and listens to their neighbours' conversations. But there's no discernible effect inside the neighbour's house, and that would be an intrusion into privacy. But it wouldn't, I would have thought, be covered by nuisance. Nothing's actually happening inside the neighbour's house. Just what they're doing there can be heard.
My Lord, can I mull that one over very quickly? Well, there are two answers to your Lordship's point. First is that eavesdropping on somebody is not something which affects their immunity of the land they occupy. The second is that if the eavesdroppee comes to Nervid, then there would be the possibility of a claim under the Protection from Harassment Act. And that's,
what I was saying. It doesn't seem to me that that kind of invasion of privacy would be
yes.
within the tort of nuisance. So I think to talk about invasion of privacy is perhaps not really what we're concentrating on. We're concentrating on overlooking.
Yes. My Lord, I misunderstood your Lordship's point. I thought it was hostile rather than friendly, so I do apologise. Learned Friend's fourth point was that nuisance is simply, well, that we said that nuisance is inapt for privacy. Now, that really goes to the fundamental nature of privacy. It is manifestly the case that if there is no obligation to create a tort of privacy, none being known to our law at the moment, then there should equally be no obligation to do fundamental violence to the nature of nuisance in order to achieve the same effect. And Learned Friend tried to meet some of the points that we'd made below to the judge about the mismatch between nuisance on the one hand and an Article 8 extension on the other. Article 8 is something to assist individuals. It's got absolutely nothing to do with where they may be and what they may occupy. So it's the wrong tool for an extension of the law. What one needs, if there is a perceived need, is a change in the law, and that is not something that is up to the courts to effect. And I add to that a point which I think is important with respect that Article 8 requires a balance. And the less this is true of nuisance, if Learned Friend is right, the more inapt the tort is as a vehicle for an Article 8 claim. Then I think turning fifthly to the facts of this case, Learned Friend made another point. We say that there is no absolute duty on the court at all to vindicate a breach of Article 8, which we don't accept in any event in which the judge didn't find, by doing whatever damage is necessary to the cause of action the claimant happens to have adopted. Hunter on this point, my lords, my lady, is quite helpful about pressing nuisance out of shape. The obligation of protection imposed on the state is a general one, and it's discharged by a number of legal actions as recognised in Wainwright. So here, it would have been entirely open to the claimants if they could have identified an offending individual to have proceeded by way of an application under the Protection from Harassment Act, or by taking proceedings for the tort of misuse of private information against those responsible for any privacy breaches.
Protection from harassment would have been quite difficult.
Well, it would
You'd have to prove a course of conduct. And
Yes.
I would imagine, I don't know this, but I would imagine that most people only go up and take the view once.
My lord, possibly. That in itself leads to this proposition that most of those are there just having a wander along to look at London's skyline and the great things that can be seen. So if you fall into that category, you're not there to snoop into the flats 34 metres away, then it follows from that you are probably not interested in what's going on in the claimant's flats. But if, to the contrary, you are, and you're the real offence in the case, then that's where the Protection from Harassment Act comes in, because presumably you'll come back and continue annoying people. But for the general visitor, who just, many of them don't stop, they just drift along, panning with their phones, taking photographs of the view, it's difficult to see how that's a harassment or a nuisance or anything at all. And then,
What is the difference between this point you're now making and your previous point? The previous point is that nuisance is inapt for a privacy. There's no tort of privacy, and there's no obligation to widen the test of nuisance to achieve the same end. And this point is you shouldn't contort, effectively, the tort of nuisance to provide a privacy remedy. What is the difference in these 2 points you're making?
well, my lord, they merge into the same. I was only trying to deal with what I understood to be learned friends' separate points. And then, my lord, the 6th point the learned friend made was really a floodgates argument. And we say that's just completely wrong.
Well, he's responding to a potential floodgates argument from you,
Yes.
I think.
Yes. Now, what he's trying to do in making his submission on that 6th point is to expand nuisance beyond its boundaries to include even those claims which wouldn't succeed under Article 8. One obvious reason being that the claimant had failed to take any reasonable steps to prevent an intrusion. And I think von Hanover was cited by my learned friend on this case, but wrongly we say, he said that von Hanover shows that Article 8 applies even where the claimant has brought the problem on herself. But that's not what the authority decides. The case was rather about the fact that Article 8 is carried into the public domain. This was the very point in von Hanover. The German courts had limited Article 8 to secluded spaces. So this principle is not at all about self-induced sensitivity. It's about the fact that Article 8 is a right with very broad parameters.
Sorry, I want to make sure I've got all these points. As I understood when you started this point 6, you're saying if you're applying Article 8, you've got to take into account, as I understand you're saying it, the claimant's own failure to take reasonable steps. Was that a point? Have I got that correctly?
Yes.
So you're saying there's a balancing exercise under Article 8?
Yes, and my lord, I was going on to say that von Hanover was not about self-induced sensitivity. It was about the fact that Article 8 is a right with broad parameters. And it's quite clear when one's looking at the human rights aspect of this that it does matter that the claimant had have acted otherwise. Of course, under Article 8 there are the aspects of legitimate expectation to consider. So it's quite a different code which is capable of assisting claimants in these circumstances. But as I've been saying all along ad nauseam, my lord, it would have been far easier for the claimants just to use no curtains.
I'm sorry, I'm still not so. Your case in relation to, irrespective of Article 8 in the Human Rights Act, your case is that there's not an actual nuisance here because, if only because, the claimants have rendered their properties unduly sensitive by failing to take steps which they could have taken, including putting their curtains up. You're now turning to justiciability, if you like that.
Yes.
And you're saying, I totally understand the point you're getting up to now, which is you shouldn't extend Article 8 in order to achieve an objective by contorting the tort of nuisance. I don't understand this last point, though, about Article 8 and failure to take reasonable steps. What is the point you're making there on justiciability?
Lord Mayor seeks assistance by me.
Well, I think the point that was made against you about Princess Caroline of Monaco was that she claimed it was a breach of her Article 8 rights to be photographed eating meals out. But I think what was said was, what the court found was, well, she should stay home and eat at home if she doesn't want to be photographed. She is a public person and she has increased her sensitivity to intrusion by eating out and about with her intended or whatever. And that was put forward as a bulwark against every case of anybody being photographed or looked at from one property to another, suddenly giving rise to a private action in nuisance. I think that's how it was put
Yes, my dear.
against you, if that helps.
Yes.
You may still want to.
I think I will.
That's what I understood. I think he was making a point.
Because this is a justiciability.
My lords, my lady, if I may, I'll call upon Miss McColgan, an expert in these matters, shortly to be Queen's Counsel in a month or two, who will, I think, be able to answer that question rather more easily than I could have done.
Can I ask you about, go back to question 1 before we
Yes.
go further? Mr. Weeks says, you conceded that overlooking can amount to a nuisance. You say, no I didn't, I only conceded malice. Well,
Yes.
so what? Can it amount to a nuisance, absent malice? Is anybody going to argue that point? I think it's what my Lord the Master was quite interested in.
Yes. My lord, we argued that extensively below. Indeed, that was one of our principal
Yeah, I
arguments.
follow that. I mean, that's in your note?
It's in our note, my lord, yes.
That's the argument you want to present to this court. You don't want to say anything more about it.
Well, no, that's right, my lord. It's all set out in our note in quite some detail. My lord, I'm very happy to take you to our submissions below in closing to flesh out, to show your lordships the passages which deal with this point in terms. If that would be
We've read the note.
Yes.
I hope we've got all the authorities now, or perhaps
We've
we
got
could.
the supplementary.
We've got the supplementary bundle that contains, I hope, the authorities of both sides. Is that right in relation to those closing submissions?
Yes.
So do that. Anyway, so we just finish this point
Yes.
now, and I suppose we ought to offer Ms. McGonigan our congratulations, and saying, well, this seems an extremely opportune moment for you to start as a semi-QC.
I will be very brief. I think that, and I'll answer questions if you want further, but I think the point about von Hanover is this. The German courts had refused Princess Caroline's privacy claims on the basis that if she wasn't secluded, she wasn't entitled to privacy. And the European Court of Human Rights said, well, that is wrong. You carry privacy as something you can carry with you in the public sphere. And where she was being targeted and harassed indeed by photographers, her privacy was breached by the photography and the publication of the photography, even at times when those photographs were taken in the public sphere. Yes. But there was no question of it being said to Princess Caroline by the European Court, you lost your privacy by virtue of coming out into the public sphere. So
That was a result of the German legislation.
that had been the approach of the German courts.
Oh.
So my learned friend, Mr. Weeks, then says, well, von Hanover indicates that under Article 8, the claimant's conduct is not to be taken into account in assessing whether there's been a breach of Article 8. I'm paraphrasing a bit, in similar fashion to his suggestion that in nuisance, which I'm not an expert on, the claimant's conduct isn't to be taken into account in assessing whether there's a nuisance. Yes, he said, so Princess Caroline, despite the fact that she brought herself into the public space, was allowed to rely on an Article 8 point. That is, her conduct doesn't fall to be taken into account in assessing whether her privacy has been breached. But that is not the case, and certainly in the Hatton case, the European Court of Human Rights took into account in determining whether there was a breach of privacy by virtue of environmental noise, specifically said, I think it's at paragraph 127, that the court would take into account factors that the claimant could have engaged with to stop that noise. And if you want a short summation of it, it's paragraph 38 of the Murray case, which is in your bundle of authorities at...
So is this all to do with the circumstances in which the conduct of the claimant will preclude the cause of action? Is that what this is all to do with?
privacy.
In privacy.
And my learned friend, Mr. Featherstone's point is, I think, that if you overexpand nuisance in order to try to accommodate privacy claims, you will end up finding nuisance where there isn't a breach of Article 8, because you may say in a nuisance claim, oh well, the fact that the claimant brought themselves to the nuisance isn't relevant, whereas it would be completely relevant in an Article 8 claim, notwithstanding the fact that we see from von Hanover that Article 8 privacy has a broad scope. That's quite different from saying it doesn't matter what the claimant does in an Article 8 claim. It absolutely does matter. And you can see that in the Murray case, which is in your bundle of authorities at paragraph...
38,
It's tab 23, paragraph 38. It's a very short point where, and Murray is a case where J.K. Rowling challenged photographs published of her son. And I'm going to sit down just now. Published photographs, challenged the photography of published pictures of her son. And what the Court of Appeal said there is, and it's the second line in paragraph 38, thus, for example, if the parents of a child courted publicity by procuring the publication of photographs of the child in order to promote their own interests, the position would or might be quite different from a case like this, and this was an Article 8 case, where the parents have taken care to keep their children out of the public gaze. So it does matter what one does. And if parents were parading their children down the streets and courting publicity, they couldn't then rely on Article 8 to challenge the attendance.
So is this one is that that would be inconsistent with the rule that it's no defence if you come to the nuisance? Is that?
That's right.
It's
And it's a
inconsistent
rule
with
which
that.
applies in nuisance but has no application in Article 8.
Right. I think we have to stop. Thank you very much indeed. So we'll carry on tomorrow morning at 10:30. Do you have any idea how long we're going to be tomorrow?
My lord, I wouldn't have thought more than 10 minutes.
Very well. Thank you very much.
All rise.